Mr. Welsh, good morning.
Good morning, Your Honor.
You may proceed.
May it please the Court, I am John Welsh. Together with Jennifer Belli, we represent the Beth Israel Deaconess Medical Center and its President and Chief Executive Officer, Paul Levy. The issue before the Court this morning is whether the arbitration provision in Dr. Warfield's employment contract requires that she be compelled to arbitrate some or all of the various claims she has advanced in her complaint. The standard of review of the trial court's decision, which rests on contract interpretation based on substantive federal and state law pertaining to arbitration provisions, is de novo. The first issue I wish to raise is whether the scope of the arbitration provision here encompasses some or all of Dr. Warfield's claims. The terms of the arbitration provision...
It would be helpful to me if you could focus your argument on the retaliation portion of her claims with respect to the scope of the arbitration agreement.
Yes, Your Honor. Well, the retaliation and discrimination claims in this case run in parallel. The retaliation claims begin, I believe, sometime in 2003, claiming that various adverse employment actions occurred towards Dr. Warfield when she raised complaints concerning Dr. Fisher's conduct. They continue up until the time of her, in 2007, at her termination, when she says she has been terminated in retaliation for having raised complaints about herself and other female staff members at the hospital. You know, I would suggest that retaliation claims are treated the same as discrimination claims for purposes of arbitration provisions. As the plaintiffs have stated, I guess it's under the complaint, paragraph 18, the employment agreement presumes good faith and lawful conduct, and neither its terms or its existence permits termination of Dr. Warfield for discriminatory or retaliatory grounds. In this case, we're dealing with a classic broad arbitration provision. As the number of cases we have cited in our briefs indicate, the operative language, all claims, controversies, or disputes arising out of or in connection with the employment agreement or its negotiations.
It doesn't use the word employment agreement.
I mean,
employment, does it? Doesn't it just say disagreement?
Disagreement. I'm sorry, Your Honor, the title of the agreement is employment agreement. And then if you follow it in paragraph 19 of the employment agreement, it sets forth the parties' express understanding that this agreement is the entire agreement relating to the subject matter hereof and any other employment or contracting relationship between the parties. So I think when you
imagine here that there was no agreement. It seems that all of the counts would still stand except maybe the tortious interference with contract. Would they not? Do any of these claims of discrimination, retaliation, defamation depend upon the existence of that agreement?
Well, they depend upon the relationship which is evidenced by the agreement, Your Honor. And I believe that is the interpretation. It's the relationship which the agreement evidences.
But the employment began before the agreement. She began work, and then the agreement was entered into after that.
Well, Your Honor, the agreement was proposed along with other employment terms before she started working as chief. She went in and started working as chief as the agreement was negotiated, and then it was finalized some 3 to 4 months later. So, in Your Honor, she started with this proposal on the table, but it had not been finalized until she was into the job on an interim basis for about 3 months.
If we accept the trial court's ruling here, will that mean that any time an employment contract is breached, then the arbitration clause goes out?
That's one of the two proposals. It could be dicta, Your Honor, because the trial court made two findings on that. First, they said if it was terminated for cause, that it would go out. And then they indicated that by its terms, the arbitration provision did not survive the termination of the contract.
But very often there are breaches, and then that's why you end up in arbitration. So won't this frustrate a lot of these agreements?
The termination for cause, no one is disagreeing, are they, that Dr. Warfield was terminated under the other paragraph?
No, Your Honor, I believe that's stipulated without cause. But Ms. Bruce is going to discuss this in more detail in her argument. But I would suggest briefly, Your Honor, that both the U.S. Supreme Court and this Court case law precedent makes clear that these findings are erroneous. They would include the Glenn Akers v. Cliffwood Corporation case in Mendez versus...
Mr. Welsh, let me ask you this. Do you agree that in looking at, in deciding this, we start first from basic contract principles to look at the arbitration agreement?
Your Honor, I think you look to see if there's a written arbitration agreement, and then you go to federal and state substantive arbitration law for the interpretation, the substantive law on how arbitration laws are interpreted. And that would be the Moses Cone Memorial case of the Supreme Court.
I'm not sure if you're disagreeing with me. It's fundamentally contract interpretation, correct?
Yes, Your Honor, but respectfully I would submit that in interpreting an arbitration provision, there is specific terms of interpretation imposed by the U.S. Supreme Court in Moses Cone and adopted by this Court in a number of cases. St. Fleur would be the last one, which says that in interpreting an arbitration provision, any doubt as to its scope is presumptively interpreted in favor of arbitration.
No, I understand that, but that might be, but that's assuming that there's any doubt.
Yes, Your Honor. I would say that also some contract interpretation principles that may apply in other contexts, such as construing the language against the drafter, et cetera, do not apply in this area. So I think there's particularized contract interpretation principles that apply.
Now, is it fair to say that you essentially want us to interpret this agreement to say that anything that arises out of the employment is arbitrable?
Yes, Your Honor.
And now, Dr. Warfield says, well, that can't be true because if there were disputes as to clinical matters, those would not be matters that would be handled by an arbitrator. They'd be handled by a peer review panel.
But those matters, Your Honor, go to her privileges as physician. And they have physicians there who are not employees. They are contractors. Similarly, her relationship with the Harvard Medical School goes to that relationship. So there are relationships that are not employment-related. But as the superseding paragraph in this employment agreement indicates, all employment issues are here. If I might very briefly, I would respectfully submit, since I have limited time, that Mr. Levy, as the CEO, president, decision-maker of this hospital, is an intended beneficiary and an agent which is covered by this arbitration provision. The case law talks about inexorably intertwined or indistinguishable. If there's ever a case where someone is indistinguishable from the entity, inexorably intertwined, it's Mr. Levy who is named in this employment contract as her supervisor. And his removal as a supervisor is caused for good reason.
Can I ask you a question? I'm sorry, I know your time is up. But with respect to post-termination defamation claims, I take it there are post-termination defamation claims?
Against Mr. Levy, there's one. And my understanding is, well, there's two. There's a self-defamation claim that the complainant had to tell people that she had been terminated. But there was also, he addressed the staff of the anesthesia department and explained his reasons for terminating him, which are claimed to be defamation.
So there are post-termination claims here. Some are defamation. I think some are also retaliation.
Yes, Your Honor.
Right. Your view is the same with respect to those, that those fall within the agreement to arbitrate? The
retaliation goes to the imposition of the post-employment severance and conditions post-employment for the emeritus professorship. And the defamation claim is a statement of the reasons of termination. I don't think that could be separated out artificially from the termination decision itself.
Mr. Welsh, under federal discrimination law, there's no individual liability of officers of corporations, is there?
I believe that's the case under Title VII, Your Honor.
And under 151B there is?
There is aiding and abetting, Your Honor, and there's also under College Town strict liability for their conduct.
Right. So when we look to how we look to what the federal courts have said with respect to your most recent claims about Mr. Levy, are we guided by federal law interpreting the interplay between arbitration and Title VII, where it's different under 151B?
I think this court in St. Fleur has indicated there was a difference between Title VII and 151B, and it said that 151B is more susceptible to arbitration than Title VII. I believe that would be the case. Again, federal law preempts any decision which burdens arbitration.
Sure, no, I understand
State
that.
courts can put increased protection and emphasis on arbitration. That doesn't run foul of federal law.
Question. Sure. You answered Justice 40 that the retaliation and defamation you thought would be covered, but you started by saying some or all. What are the some that might not be covered?
Well, Your Honor, there are aspects of the case which the court could find that fall outside the scope. I believe it's all covered, Your Honor. You know, I leave it to the court. I think the toughest issue is Mr.
I agree with that.
Mr. Glovsky will be arguing with respect to Dr. Fisher. I think that's the toughest one. But then there's the issue of whether a stay should be in place if you have common facts being litigated both in the court and before the arbitrator, and the arbitration decision will be collateral estoppel on many of the parties in the litigation, whether or not the litigation should be stayed until the arbitration makes the central fact findings in which the other facts depend.
Thank you, Mr. Welsh.
Thank you, Your Honor.
Ms. Spruce?
May it please the Court, I am Tracy Spruce. I represent Harvard Medical Faculty Physicians, which I refer to as HMFP. And I want to address briefly the issue that Justice Borenstein raised sua sponte, which is whether the termination of the employment contract automatically terminated the arbitration clause as well. And it is not the law in Massachusetts or under federal law that as a matter of law an arbitration provision terminates coterminously with the contract in which it resides.
Well, that gets back to the question that I asked originally. If his position is correct, then every time there's a breach of the employment contract, or many, many times, that has an arbitration provision, that would make the arbitration clause unenforceable. Is that right?
If the decision is allowed to stand, you are correct. And in fact, I think the decision in the Gevin construction case highlights the error of the Superior Court's decision in that case, because the Court said that even if there was a material breach there, that doesn't necessarily mean the arbitration clause expires.
What about the other half of it? That is, that the agreement says if Dr. Warfield is terminated not for cause, under paragraph 12, the agreement ends right then. And I mean, and the argument that there's another provision that does, that the confidentiality one, I guess, which explicitly says this survives the agreement. There's no such language in the arbitration clause. So is the cases that you're relying on also deal with that?
They do. In fact, the Carpenter versus Pomerantz case addressed exactly that question, which is whether the arbitration clause expired with the employment agreement in which it resided. And the plaintiff there argued that it did because the confidentiality and non-competition provisions had an express survival term, but the arbitration clause did not. The appeals court rejected that argument for 3 reasons, none of which is determinative. I think it's a totality of circumstances analysis.
That's a slightly, that's the flip side of the coin. That's what survives. This has paragraph 17 saying any claim consultative dispute arising out of or in connection with this agreement, and then paragraph 12A says this agreement shall terminate at the same time. So it's not as if you've got different, it's not as if you've got, as you had in the Carpenter case, you had a, non-compete that didn't survive.
In the Carpenter case, the non-compete did survive.
I mean, did survive.
The
And so that
arbitration
was
clause
saying,
didn't.
But here, I'm just looking at the contract interpretation that says this agreement, everything within this agreement is arbitrable. Everything, very broad, I agree. But I've got another provision that says this agreement terminates when she's terminated from a position.
Well, if you want to look at it as a matter of pure contract interpretation, the result is still that the retaliation claim against HMFP is arbitrable, because what you have to look at is whether there are other indicia in the contract that the parties intended the arbitration clause to survive the termination of the contract. That was another factor that the Carpenter court looked at.
That's only if the language is unambiguous, correct? If the language of the agreement is unambiguous, I then go to, and then there's a series of how do you interpret. And as Mr. Welsh pointed out, in some cases we say you construe it against the drafter. In insurance cases, we tend to construe it against the insurer. In arbitration cases, you tend to construe it in favor of arbitration. But you have to get, don't I have to get to an ambiguity of some kind?
I don't think the case law supports that analysis, Your Honor. In
But
fact,
that's basic contract law, isn't it?
it is, except that when you're talking about arbitration, when you have a broad clause like you do in this case, there is a strong presumption in favor of arbitrability
Oh, no
that has
question.
to serve as the foundation of the subsequent interpretation. And here, particularly with respect to the claims against HMFP, they actually arise directly out of the contract. And so if you want to look at the Litton case and the Nolde case out of the U.S. Supreme Court, the claim against HMFP is that HMFP has retaliated against Dr. Warfield by asking her to work full-time and by transitioning from her endowed chair to a distinguished chair. Paragraph 5 of the employment agreement addresses exactly that issue at HMFP Record Appendix pages 21 and 22. And what Dr. Warfield is claiming is that HMFP's efforts to execute its post-expiration obligations under paragraph 5 of the employment agreement is retaliation. So in order for her to prove her claim, she has to take the position that paragraph 5 of the employment agreement means something other than what HMFP is trying to do. That requires an interpretation of paragraph 5, and that places her claim of retaliation squarely within the terms of the agreement, which makes it susceptible to arbitration.
Thank you, Ms.
Thank
Spruce.
you.
Mr. Govsky?
May it please the Court, I'm Richard Glevsky. I represent Joseph Fisher, Dr. Joseph Fisher. There are 4 points I'd like to try to convey to the Court this morning. First of all,
There was some reference, is Dr. Fisher no longer at Becker's here?
Dr. Fisher has resigned. He is no longer employed there. First of all, when you look at the complaint, as I'm sure you have, you'll see there are 125 substantive provisions in the complaint. 91 of those, the first 91 of those, involve Dr. Fisher in some way, shape, or form. His conduct in this case is completely intertwined with the claims against the other defendants. And the case law in this jurisdiction, Myrick, Mugano-Bornstein, but in other jurisdictions as well, make it clear that when the conduct of an individual is so intertwined with the conduct of the institutions that is alleged, then that individual should be included within the content or the contours of an arbitration provision, even if he or she is not specifically mentioned or there's no reference therein to employees. I would submit to this Court that if this Court should find that Dr. Fisher is not subject to this arbitration provision, it would wreak havoc in the workplace. Think about it. Every employer with an arbitration provision in its employment agreements with its employees would have to go back and review each of its contracts. In most instances, would have to revise them because they will not state that employees like Dr. Fisher and others are covered. Because in the workplace, not only in the Commonwealth but throughout the country, employers have been relying upon cases not only like Myrick and Mugano-Bornstein, but cases from the Second, the Third, the Fourth, and the Sixth Circuit have all come out in the same place.
Mr. Glovsky,
Yes, Your Honor.
very, very often what's at issue in those cases, and perhaps I'm wrong, what's at issue in those cases very often is claims for failure to promote disparity in pay, demotion, allocation of work responsibilities that are implemented by the head of a department, Dr. Fisher, in those cases. How do we deal with the cases where, and I'm not I've just got the complaint at this point, I've just got allegations of a complaint, but where, if true, the allegations couldn't, the conduct complained of couldn't possibly be in promotion of the employer's interest. Thank you very much. So take an egregious one that doesn't have anything to do with this. I mean, that there's a beating up of somebody in the workplace. Supervisor, lost her cool, jumped across the desk and smashed somebody in the face. And there's a very broad arbitration agreement. what do we do with that? Do they send that to arbitration?
In those circumstances, and I think Judge Selye's opinion
Yep.
in the McCarthy case is somewhat helpful in this regard because he talks about the circumstances that are outside the scope of one's employment. The cases that I referenced, Second, Third, Fifth, and Sixth Circuits, all talk about the quote-unquote agency relationship. In other words, the act of the employee is within the contours of what he would normally be expected or she would normally be expected to do.
Well, certainly if one looks at the allegations against your client, that is not what Beth Israel would be expecting that person to say or do. Only allegations.
That's true, but those allegations are clearly distinguishable, according to the cases that I've recited, based upon the nature, and again, I refer the Court to the McCarthy case because I just think Judge Selye does a good job. For example, he talks about ultra-virus establishment of another company and piercing the corporate veil to go after an employee or employer or party who has acted outside the scope of the corporate existence. And he's got several references in his opinion which I think plainly demonstrate what this distinction is. If I could make one more point, and that is one of the fundamental tenets and desires of employers when they enter into employment agreements with arbitration clauses is to have a private forum for the resolution of disputes. In this particular instance, especially involving Dr. Fisher, but also involving the institutions of Mr. Levy, there are allegations such as Dr. Fisher's storied past, his ugly habit of demeaning women, his abusive treatment of professional women. This allegations that go on, which I would submit are beyond normal pleadings, but nonetheless they're in the complaint, and they have the sanctity of having been filed in a complaint. That is exactly the type of situation that people like Dr. Fisher, Mr. Levy, and particularly the institutions want to avoid.
Dr. Fisher wasn't even there when this agreement was entered into.
That is true, Your Honor. He came shortly thereafter. But the point is that the document itself was designed. One of the chief purposes, case law is replete with reference to this, of keeping matters which are controversial in a private forum. Now Dr. Fisher and the other defendants are exposed to allegations which we will ultimately, I think, demonstrate are not true and not provable. But nonetheless, it's out there. In fact, the day after this case was filed, an article appeared in the Boston Globe.
Thank you, Mr. Glovsky. Ms. Student? I'm sorry, Ms. Zucker, you're going to do it.
I can't even begin to be Ms. Newton. Good morning, Chief Justice. May it please the Court. The suggestions made by the appellants in this case would create arbitration by operation of law and not consent. That is not the law here. It's not the law federally, nor should it be. We ask that the Court affirm the decision of the trial court denying the defendant's motion to compel. We ask that it remove the stay on proceedings in Superior Court and permit Dr. Warfield to proceed in proof of her claims for gender discrimination, retaliation, and other tortious conduct against the VIDMC, its physician association, and Mr. Levy and Dr. Fisher. Now, we ask the Court to do so mindful of the healthy regard this Court must have to policies favoring arbitration, but equally mindful that this Court has said, and the federal courts, in fact, have insisted, that arbitration is a creature of contract, and that the purpose of arbitration clauses is to submit to arbitration matters where the parties so agree, but not force parties to submit to arbitration matters where they do not and did not agree. There are four reasons for...
You've got a very broad arbitration clause here.
Your Honor...
So let me just ask you this. So there are a series of allegations, and they are allegations, that Dr. Fisher engaged in certain kind of conduct. This is long before there was any termination, and that your client went to various people in the hospital and made certain complaints, and the hospital reacted or didn't react from your point of view. Why is that not a dispute, claim, controversy arising out of or in connection with this employment?
Well, I think
with this agreement.
It is with this agreement, Your Honor. And really, the first reason why arbitration cannot be compelled in this circumstance is the first principle interpreting whether or not arbitration should be compelled is to look at the contract. And the contract here was entered into after Dr. Warfield was an incumbent in her position as chief. She had been a member of the medical staff at the BIDMC for 25-plus years. She was a faculty member and holding an endowed chair, full professorship at Harvard Medical School.
Well, certainly the fact that the contract wasn't formally entered into until 4 months after she'd assumed the position should make no difference at all. That's just not uncommon.
Your Honor, it makes something of a difference, particularly in this context. The parties to the agreement are the Physicians Association, BIDMC, and Dr. Warfield. At paragraph 1, in the agreement, it states employment. And in that section, it acknowledges that she has a host of responsibilities and roles and grievance mechanisms available to her on the basis of those responsibilities and roles that survive and are not swept into the agreement. And within that context, she assumes the position as chief. She is not told at that point, nor should she fairly expect, that her assumption of the position, qua position, is dependent upon her signing an agreement. They did not so condition her appointment. So in that sense, Your Honor, I believe it is meaningful. It is not the thing upon which you need to rely. I believe that what you need to rely on is the fact that this was a narrow agreement.
But what about the superseding clause that says this agreement supersedes any and all previous discussions, understandings, or agreements between the physician, HMFP, and/or the hospital?
That, I think, has to be understood within the context of paragraph 1, defining employment and acknowledging the full context of her other relationships as, frankly, a traditional merger clause, and understanding that the parties, that for her employment in terms of chief and the duties it set out, that was the agreement. Dr. Warfield.
Any other employment or contracting relationship, this supersedes it.
Well, but to read, what we have to do is step in the totality of the circumstances. What we have to do is look at this agreement from someone in Dr. Warfield's shoes. That is what we're obliged to do when we are analyzing a contract.
We have to look at it from all parties.
To be sure, Your Honor. And what we have to do in this circumstance, it seems to me, is Dr. Warfield, in looking at this agreement, which reads in its arbitration clause that controversies and disputes arising out of this agreement or its negotiation, and to address a point raised by Justice Cohen, the clause is unusual. It doesn't do what the Carpenter versus Pomerantz clause did, which is say this agreement or its termination. There's a very simple way of avoiding the problem about which you're speaking, and I understand the problem. But it is to use the standard clause, which is to say this agreement or this employment and its termination become arbitrable.
Is that typical?
That is typical. That is the clause used in Carpenter versus Pomerantz. And with great respect to my good colleague, Pomerantz, the Carpenter case, is decided explicitly on the grounds that the termination was rendered an arbitrable event in the clause, expressly not here. And in fact,
the agreement has termination, specific provisions governing termination.
And we do not dispute that she was terminated not for cause. With great respect, we do not dispute a single provision in this contract. We do not dispute that she was terminated not for cause. We do not dispute that the termination took effect. We do not dispute, in fact, that upon termination, she moves from being the endowed chair to the distinguished chair. We do not dispute any of that. And so the contract, her claims, all her claims, can and should be maintained, frankly, without reference to the contract. And the issue is her reliance on them to prove or make out her case. Now, I would like, with the Court's permission, to look at the allegations, because some have been said, and the reply brief, frankly, works quite hard at turning the allegations in Dr. Warfield's complaint into allegations about the agreement or its negotiation, which we believe is unfounded. For instance, with respect to Dr. Fisher's conduct, and at Dr. Fisher's conduct, at paragraphs 32 and 33, it talks about some of his conduct with respect to her and his refusal to deal with her. In 48, It describes his independent threats of reprisal. In 49 to 53 and 94, it sets out his individual acts of retaliation. And we understand, it's well established in the Commonwealth, that threats of retaliation, threats of reprisal, make out a cause of action. Now, it makes sense to notice paragraph 42, which is an admitted paragraph to this extent. BIDMC and Mr. Levy admitted that Dr. Fisher's had, quote, had no place at the Beth Israel Deaconess Medical Center. Had no place. Now,
I'm sorry, I don't understand. What do you mean, had no place?
with respect to this paragraph specifically dealt with Dr. Warfield coming in and supporting a junior member of the faculty and staff who was complaining of Dr. Fisher's
are you talking
conduct.
about had no
And the
place and
BIDMC
engaging in
says
the
that
conduct?
conduct has no place. Now, with respect to the independent animus and evidence against the BIDMC and Mr. Levy, again, these allegations find no anchor in the agreement. They are that he failed to respond. They are that he engaged in gender stereotyping and that he talked about her playing the
there's
victim.
a dispute as to whether he did, right? There's a dispute. There's a claim. There's a controversy.
sure.
I mean, she was going to see him as part of her employment, correct?
She was going to see him as part of, he was CEO of the hospital, she was a chief. She reported to him not just because the contract said so, because that is hospital practice, and that is indeed what we say in our complaint. So she reports to him per hospital practice.
But also by agreement.
To be sure, it's also by agreement, but there is no dispute here. In other words, the better rule in these cases, and indeed some of the broad claim cases that the appellants have drawn your attention to, are very willing to look at and do. It is the better rule to look at whether the allegations require interpretation of terms or rely on the contract to reach their result. And I would draw your attention to two specific cases cited by the defendants in their briefs. And one is the Collins versus Akins case, and the other is the Parfee Holdings case. And in Akins, having said what the appellants like, which is that arising out of and related to means broad, Collins goes on, in fact, to find almost all claims not subject to arbitration because although they dealt with the ongoing relationship of the parties in that circumstance, they were not grounded in a dispute about the contract terms, nor is this case. And so
But it doesn't, again, forgive me, but paragraph 17 doesn't say disputes about contract terms.
to be sure, Your Honor, and the clause in the Collins case is actually broader, or as broad, as what the words are here. And we would caution the Court. Contracts, as I believe the trial court rightly determined, contracts and the clauses therein must be viewed in their totality. The cases we have cited, there are no magic words. And the Second Circuit tradition cited by Mr. Glusky, if you read the Sokol Holdings case and the Ross case actually cited by the amici, you will see that the overall context of the contract matters. In this circumstance, Dr. Warfield's position in the hospital matters, because if she were to look, as any incumbent chief signing a contract looks at an agreement she is signing, and it does not say termination is arbitrable, and it goes on within the clause itself, as this one does, to say, if we have a dispute, we will continue to perform under the contract, which suggests, rightfully, that if we're not doing what we're supposed to do and we can't resolve it during the course of our relationship, akin to a collective bargaining context, right, we will then go into arbitration over those disputes. The agreement is narrow. The clause itself contained therein must also be narrow. And now, if I could, turn to the issues of the termination clause and the third parties. Because The question here is, if it is narrow, under this Court's jurisprudence, unless you are absolutely sure, unless you are sure that she intended to arbitrate this sort of dispute, arbitration should not be compelled. Even if the clause is broad, even if the clause is broad, if the matters involved here are not related to the agreement, as they are surely not, then arbitration should not be compelled. And we argue that with positive assurance, this Court can and should say that arbitration isn't compelled generally. Now, turning to the termination clause argument here, Dr. Warfield's claims accrued at the time she was terminated. And under Clause 12 of the agreement, that accrual signified simultaneously the termination of the agreement. Now, that's an unusual express provision. The parties don't contest it. In some of the case law, there's a contest about when did the thing terminate. And that is one of the questions, right? That may subject the matter to arbitration. Here, there's no contest. It accrued on and after. With respect to her complaints.
So under that theory, Dr. Warfield does not claim she should be named distinguished professor or professor emerita.
With respect to her complaints about retaliation, I believe they have been miscast. And I would ask you to look at the final counts in the complaint, particularly 105 to 120, because what you will see is that her complaints post-termination really are twofold. One is a generalized complaint that, having been terminated improperly, as she alleges, she cannot, she doesn't get the benefits. There's no disagreement about what those benefits are. That's not a contractual issue. Second, she complains that she is not being treated the way other former chiefs are being treated as a matter of practice. That also doesn't ground in the complaint. And I must admit,
it doesn't ground in the complaint.
It doesn't. I'm sorry. Thank you, Your Honor. In the contract. And I must admit one final point with respect to that. The parties in this matter have agreed as to what Dr. Warfield needs to do to maintain her chair's stipend. That is no longer an issue in this case, and the parties well know that there has been an agreement with the parties about the distinguished chair position and her stipend. There is no argument about that in this case. Finally, with respect to third parties, it is abundantly clear that if all we were doing is asking for a derivative claim with respect to Mr. Levy and this Court were to find, as I don't believe it ought, but and it were to find that the corporate claims are arbitrable, he might be forced into arbitrate. We might be forced to arbitrate claims against him in arbitration. However, individual liability attaches. With respect to retaliation, this Court has been abundantly clear that individual liability attaches. He is not being sued in his corporate capacity, but in his individual capacity. With respect to Dr. Fisher, he is a senior colleague at the medical school, and he was a colleague at the BIDMC with no supervisory authority over Dr. Warfield. In such circumstance, he cannot be held to be an agent of the corporation for purposes of enlisting the benefit of its arbitration clause. He is not an intended beneficiary. The succession clause that sets out the benefit where the contract benefits, to whom it inures a benefit, does not list agents, employees, and certainly other co-workers. And finally, essentially, the intertwining argument made by the appellants suggests that this Court should invoke its principles of equitable estoppel. It should engage in judicial interference with what the straight contract would read in order to save the individual defendants from some unfairness. Once again, this arbitration is a creature of contract, and where the identity of the individual parties is unclear. At the time Dr. Warfield signed her contract, indeed, it was Michael Rosenblatt, not Mr. Levy, that signed the agreement, and Mr. Fisher, Dr. Fisher, was not even an employee. It would work an unfairness to Dr. Warfield, quite frankly, in the extreme, to have a narrow contract into which she entered, defining certain duties of her job, to be used offensively by an individual co-worker to force matters into arbitration. The answer ultimately to the questions this Court has had about the fairness of Dr. Warfield's position, the question is a simple one. It's a drafting question.
Thank you, Ms.
Thank
Silver.
you.
We'll take a short break.